Okay, we're on the record of the people of the state of Michigan versus Carnell Michael McCurry in all lowercase letters. 2305645. Mr. McCurry is charged with count 1, assault with intent to murder. Count 2, assault with intent to great bodily harm less than murder. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felony assault. Count 6, 7, 8, and 9, weapons, felony firearm. Also count 10, weapons, felony firearm. Set for a motion here today. Appearances.
Edwin Sawaki, V5 Court Agent A, appearing on behalf of the people.
Mr. McCurry, say your name, please.
Carnell Michael McCurry Ill, all lowercase, acting appropriate persona of the Michigan Constitution, 1963, Article 1, Section 13.
I know that you state that you don't need them, but the laws that I have to follow state that Mr. Watson.
Well, I object because
I understand you should object.
I made a motion because he does not represent me. He is not responsible for me. I made a quasi contract, and it was served on the prosecution as well as this court.
Before we jump into today's chaos-filled hearing, let me set the stage for you, because this case isn't just another sovereign citizen meltdown. Oh no, this one is on another level. We're talking about a man facing 10 felony charges, including assault with intent to murder his own brother. And instead of hiring a legal team, consulting an attorney, or even trying to preserve a sliver of freedom, he has chosen the one path guaranteed to fast-track himself straight into a lifetime behind bars, representing himself while armed with YouTube legal theories, imaginary contracts, and maritime law fantasies.
And the contract is clear and it must be enforced. Anything after this point, performance is accepted for the relief in the documents. There is not a corpus delicti. Where's the witness? Where's the victim? Where's the injured party?
You're getting into your motions.
I mean, no, it's a quasi contract which I sent to the courts, and it's clear. I mean, they have to either admit or deny the statement.
Okay, well, what does that have to do with Mr. Washington not being present?
Well, he's not my attorney. He's not responsible for me. I'm acting in appropriate persona, which the federal and state constitutions allow.
That does allow, but it also requires me to have an attorney present. That you request an attorney at any moment during your.
And I object. Jurisdiction is challenged must be proved by the people on the onset of the
And I get that until Mr. Washington is present, because for my job, I know you have a job. I have one too. For me to keep my job, I have to follow certain rules, which means that Attorney Washington needs to be present for me to hear these matters.
Well,
regardless of what you say, if I don't do that, I'm violating law.
Well, I mean, your performance is acceptance, Judge. You've seen the documents, you read the documents.
This is not a contract that I'm talking about.
Well, I'm saying, no, I made a presentment upon this court of people, a quasi-contract. Your favorite kind of quasi-contract.
Yeah, and this is not civil law, so I'm not doing contract.
It's not civil law. We're dealing in an Admiralty Maritime law court.
Right out of the gate, you can already see where this hearing is headed. The defendant launches into his identity speech, complete with misquoted constitutional sections and misunderstood Latin phrases. This is classic sovereign citizen groundwork. Overwhelm the court with complicated sounding terms so it feels like you're invoking deep legal principles, even though none of it actually applies. What makes this moment so fascinating is the judge's expression. She's already heard all of this before, probably dozens of times, but she still lets him speak, giving him every opportunity to clarify his position. And yet, instead of focusing on the life-altering charges against him, he wants to debate phrasing, contracts, and the metaphysical boundaries of court authority.
No, this is the jurisdiction that this court is operating under.
I can't move forward. Did you email me all the documents?
And it says clearly right here.
Can you let me finish my question? Which email did you send it to?
The one that your officer gave.
Was it the courtroom 438?
Yes.
Okay.
I made sure everything was delivered. It was served upon you as well as the people. And everything is being tacitly admitted to in this document.
I'm just trying to proceed make sure I have your motions. Because I have
Well, it's not a motion, it's a quasi-contract. Which the Supreme Court of Michigan allows.
We can go back and forth. I'm not ever going to say that it's a quasi-contract. So
I'll just move for lean, Judge, against all parties because everyone is in default ground. And the law is clear from the Michigan Supreme Court, which respondent superior applies to this court that the decision stand. Stare decisis, Your Honor. This court is in default. as well as the people by their tacit agreement.
Okay, so
I mean, the law's clear. He read the paperwork. He's a bar attorney. If he doesn't know the
Mr.
law,
Washington is not present. I have to adjourn this.
he's not representing me. That's why I
May 30th
objected.
at 1:30. Can you make that day?
May 30th. Okay, I mean, I have a question, if I may.
If you answer mine, maybe.
May 30th, I have no choice. I'm here under direct threats and coercion by this court and corporate courts
Can
in
you
this
make
office.
it May 30th at 1:30?
I sure can.
Okay, so what's your question?
Well, my thing is, I mean, I didn't know that the judge could ignore the Constitution in which they were sworn to uphold the law of the common law court of the Supreme Court. All other courts are legislative created courts, which they make the courts, they make the law to enforce them. They're commercial statutes.
This is where things start spiraling into that classic sovereign citizen alternate universe. He claims he served the court and prosecution with a quasi-contract, which, in actual legal practice, is something courts can impose, not something a defendant writes up on notebook paper and declares binding. His tone suggests he thinks this contract overrides statutes, case law, jurisdiction, and functionally the entire judicial system. What's happening here is a misunderstanding of legal terminology mixed with an attempt to outmaneuver the court using made-up rules. This is a common sovereign tactic. Create a fictional document, declare it binding, and hope the judge gets confused. Spoiler, she does.
I mean, I'm just saying, I'm what my contract adhered to. The people are remaining silent. They have agreed.
What's your question? You said you have a question.
I would like to know, can I go to the courts? As long as I'm going to court, I can leave home, because I would like to go to the federal court so that I may file a lien against the state of Michigan, the corporation, and the cities and county and state for crimes. You know, the prosecutor, Kim Worthy, has committed crimes against me. It's well documented. You're an officer of the court.
Is that where you filed with?
Yes.
Okay.
I mean, you are an officer of the court. You swore to uphold the law, and the people were acting criminal against me, and it's well documented. I have the alleged complaining witness on this case, Norman McQuarrie, has perjured himself.
Your brother?
Yes, I have documents here I'd like to admit to the court, so that I can impeach him. And like Kim Worthy has issued a list saying,
That was something that happened during
Well,
the testimony.
ma'am, what I'm just saying, jurisdictional challenge.
Once we get there.
No, what I'm saying is jurisdiction has been challenged. It must be proven from this point. Out of court statements are hearsay, man.
Oh, I'm very clear.
You see what I'm saying? So where's the corpus delicti? At this point, I moved to challenge jurisdiction again in the court. If not, I ask that the court strike this case from the docket for lack of jurisdiction, which the case law clearly.
Now we enter the maritime law dimension of the sovereign citizen universe, one of the most persistent but least accurate claims they make. According to this belief, gold fringe flags or courtroom decor somehow convert the entire legal system into a naval tribunal. In reality, maritime law governs things like shipping contracts and ocean disputes, not attempted murder in Detroit. What the judge does beautifully here is avoid reacting emotionally. She calmly redirects him back to the process, reminding him that none of what he's saying has any bearing on the case. This moment is crucial because it highlights the contrast. The court is rooted in real law, while he's anchored in theories that sound official but collapse under any factual examination.
But I cannot.
Well, is it okay for the prosecutor's office to commit crimes in violation of MCL 750.505? You're under 18.
It's okay. It's not okay for anyone.
Well, I mean, this is what's going on. I'm being deprived of my liberty as an American sovereign citizen, threatened under direct force, coercion, and direct force and coercion under Coins versus United States, 19 U.S. 264. They have incorporated the inhabitants. It started in Washington, D.C. and made us corporations today, and these are commercial courts. The Supreme Court has clearly stated everything and outlined everything, and it's in the law. I'm requesting that my contract be adhered to. The quasi-contract, which the Michigan Supreme Court and Casketen versus Magritta speaks of. I'm using the law of the land and of the state and the Constitution, and I'm being deprived of my liberty rights. So I'm asking that this court issue a writ of habeas corpus to have this case dismissed.
Against you?
Pardon? No, I'm saying against the state. You know, I'm here.
This is one of the most important parts of the entire hearing. He tries to argue that attempted murder is a commercial statute, something he believes invalidates the court's authority. But the judge shuts that down with actual statute references, clarifying that attempted murder is a criminal offense codified and absolutely within the jurisdiction of this court. What's striking is how he completely ignores the seriousness of the charge. Instead of acknowledging the gravity of facing a potential life sentence, he's preoccupied with arguing labels and definitions. This is a common tactic among sovereign citizens. Focus on technicalities to avoid engaging with the facts. But in real courtrooms, facts always win.
I've committed a crime. Where's the corpus delicti, the body of the crime? I mean, everything is listed here, from the Michigan Supreme Court to the U.S. Supreme Court.
You know I would have to hear testimony to know that.
Well, ma'am, once jurisdiction is challenged from this point, they have to present what they have. If they can't
make a
prove,
decision on something I haven't heard?
but did you read the document? I mean, like I stated here on page 4, man, read something real quick.
No, because I have to wait for the actual hearing to hear both parties on the record. I'm not gonna respond to your
What party is
email.
missing?
I just told you.
Oh, the attorney doesn't represent me. This is what I'm saying.
And we all agree.
You know, I mean, so
We
I'm
all
just
agree
saying.
they do not represent.
Okay, well, I mean, your performance is accepted from all parties, so if you issue a lien to federal court against all parties,
Okay.
because my rights are being
I will
violated.
allow
right?
you to go to federal court. Is that what you're asking?
Well, I know in the order it says as long as I'm going to court. I mean, it
Yeah.
doesn't really matter what court does it. I mean,
Well, you were asking if that was okay. I'm just letting you know. You're allowed to go to court. So May 30th and 1:30? Attorney Washington has confirmed that you will be here to sit.
I've tried to call this man. He don't even answer his voicemail.
What are you calling him for if you don't need him?
No, but what I'm saying is I was just calling him to confirm with him, just asking a few questions. or whatever.
Oh, as a
And
attorney.
he didn't even respond. I don't need an attorney, man.
This portion is a masterclass in circular logic. He claims his rights are being violated, but refuses to participate in the legal process designed to protect those rights. He asks to leave to file liens against the state and other officials, another sovereign citizen hallmark. These liens are typically frivolous documents designed to intimidate or harass government employees. The judge remains patient, reminding him that constitutional rights don't give him unlimited freedom to roam around while facing 10 felonies. What's most telling is his insistence on jurisdictional challenges, even though the judge has already explained why the court has proper jurisdiction.
That confirms my reason why I'm here. Because time you have to ask him a question, he has to be.
Well, can I ask you, where is the victim here? Because crimes against the state are not permitted under Cohen versus Virginia.
The complaining witness is not present because the day is not changed for them to be present. to testify.
Well, once jurisdiction is challenged, it must be proven on the record, Your Honor. I mean, you're ignoring the constitutional mandates of the Supreme Court, which you are bound
It's
to.
all the law of the Jews. Okay, so May
You
30th.
told me to put it in writing, I did it, you guys.
I just want to confirm that you sent everything.
I did.
I don't want us to labor over any points on the 30th. I want to make this as concise.
Well, I mean,
as
you guys are already in default, so I'll be enforcing the lien in the federal court, as well as seeking prosecution of this court as well as the state corporate office, because my rights are being
I understand your
violated.
route, which you're going, but I'm just telling you, I just want to make sure I have all your motions. Okay? You sent them all.
No, it's a quasi contract. If you look up
You
a
sent all
quasi
of your
contract,
documents to the
Pardon?
court? You sent all of your
I
documents? that
sent
you want read?
everything
Okay,
to the courts. I sent it to this gentleman here. He thinks it's funny. But see, what he doesn't know, his tacit,
It doesn't matter what
remaining
he
silent,
thinks.
he agrees to everything
Mr.
that's
McCurry,
done.
I don't care what he thinks.
Yeah,
I don't.
statutes
I
are
don't-
commercial, Your Honor.
Okay.
And this is what the courts are enforcing, commercial
Therefore,
statutes against
we will
citizens.
see you on the 30th, 1:30, okay?
Right.
Anything for the people?
Your performance is accepted. I just want to state this on the record. Because right now he wants to speak, but before the hand, he doesn't want to admit or deny what's been presented.
He just said
His-
there's nothing
his-
to
his
say
sup-
for the record.
his
So he
sup-
does not want to speak.
Well, may I say this? His supervisor has committed felonies in this well documented. I did 15 years and 8
You should call the
months.
police in.
I did. I contacted FBI, everybody. No one is.
Here comes one of the most ironic moments of the entire hearing. He insists he doesn't need an attorney, but admits he's been desperately trying to contact that same attorney because he has questions. This contradiction exposes the core problem with self-representation. He has no idea how the legal system actually works. The judge halts the hearing specifically to protect his constitutional rights, because proceeding without counsel when he clearly wants counsel's guidance, could invalidate the entire case. The court is doing everything in its power to protect him from himself. Yet he continues arguing that the system is corrupt.
Well, you say what now?
Judicial branch, we don't
Well,
court
but
crime.
what I'm saying is the court sua sponte, if the court feels that there's been a violation of the law, the court has the power to enforce the law. If you look at People versus, what was the case? People versus Hampton, where Judge Crockett at the time overruled the jury's decision, and the Michigan Supreme Court ruled that where a judge feels something is being violated or.
The jury's decision.
Well, no, I'm just saying it shows you that you have the power to
To
overrule.
a jury, there has to be jurisdiction.
I'm challenging jurisdiction.
I know. So we have to get that, Mr. McCurry.
You're a legal practitioner. You're a licensed attorney. You're an elected judge. You know the law, and the law is being violated. Going back to Coins versus Virginia, they made us slaves and names in corporate capital letters. 19 U.S. 264 Coins versus Virginia. Everything that is being done is unconstitutional. It's criminal. I am an American citizen, not a corporate citizen. We all have. And this court is using commercial law. Even this flag that is being flown is a military court, Admiralty Maritime Court, and it's all Supreme Court. You can laugh all they want, but.
As we wrap up this hearing, one thing becomes crystal clear. The judge demonstrated remarkable patience and professionalism in the face of endless pseudo-legal jargon, contradictions, and attempts to derail the proceedings. Despite the defendant's insistence on maritime laws, sovereign status, and fictional contracts, the court repeatedly reaffirmed the real legal standards that apply: jurisdiction, statutory authority, and constitutional protections. What we witness is a textbook example of how misinformation and misunderstanding of the law can trap someone in their own narrative, ultimately preventing them from defending themselves effectively